Welcome back to the fourth episode in our second season of our What's on Tap series. I hope you enjoyed our most recent episode regarding Regulation F communications, produced by everybody in the Philadelphia office except me. But I'm glad to be back joining you today to talk about cramming it down, and we'll get into what that means. So I'm joined today by Scott Best. As a reminder, my name is Deane, an attorney in the Philadelphia office practicing both in Pennsylvania and New Jersey, as well as in our bankruptcy department. First, as always, we're going to start off with another beer recommendation. This time it's my recommendation, and what I have for you today is the Mayor Blonde Ale. This comes out of the Twisted Ginger Brewery and Tap House, which is in the Manayunk neighborhood of Philadelphia. If you're familiar with Philadelphia neighborhoods, you're familiar with row homes, and that's why I love visiting the Twisted Ginger. It is a 3-story row home converted into a brewery, tap house, and pizza shop. So if you're ever in the Manayunk neighborhood, definitely recommend stopping by. Don't have too many though. It's pretty hilly there and it can be dangerous walking home after a long night.
And as the beer indicates on its label, it is a good beer for trimming, grilling, and chilling.
Excellent summertime beer. Of course, we just finished that, but long into football season, if you're going to be on the couch all Sunday watching the games, not a bad thing to have a case of lying around. What do I mean when I'm talking about a cramdown? So for all of those interested, this is a bankruptcy episode. So Scott and I are going to walk you through the process of what a cramdown is, why it's really important to understand what a cramdown is, and how to essentially review, understand if your rights are being protected based on the bankruptcy code and what the debtor's ability and eligibility for a cramdown is. So again, just to go over our topics of discussion, first, what is a cramdown? Then we'll cover when it's an option for a debtor. And then finally, Scott and I will explain why they're so important to understand now based on the current auto market. So first, let me start by defining a cramdown. So for those of you unfamiliar, a cramdown is essentially the term we use in the bankruptcy world to define a debtor who has filed a Chapter 13 bankruptcy. They've also filed what's called a Chapter 13 plan, and that plan proposes to pay the balance of the car loan owed to the secured creditor. Now, the problem, and that for the creditor's perspective, where this cramdown comes in, is that a cramdown doesn't actually pay the full balance of the loan. Instead, it only pays the fair market value of the loan, plus a nominal interest rate, or what we'll explain further, called till interest. So from the creditor's perspective, this means you're going to be facing a reduction of your principal balance as well as a likely reduction of the interest balance that you're going to collect on this loan. Ultimately, the creditor's contract, the delinquency status of the loan, things like that are not considered by the bankruptcy court when determining if a debtor is eligible for this cramdown option. Instead, it is all about what the debtor's position is. How long ago the car was purchased is a big factor, but outside of that, it's the debtor's eligibility based on their income and assets in terms of how much of this loan they're paying back. So, Scott, what I've just described seems like a bit of an unfair process, but is there a way you can think about cramdowns that make them seem fair to our clients?
So, as you said, the process of a cramdown, as with many things in law and in litigation, don't always seem fair, but the statute allows for it, so the courts have said it is fair. One way to kind of look at this, and as we've discussed in prior episodes, is the replevin process and pursuing a deficiency balance. One way to look at this is your replevin, when you sell a car to replevin, you're getting a reduced value and you're left to pursue the deficiency balance on the contract. A cramdown kind of works in the same way in that it reduces the underlying principal balance due. The courts say this is what the car is worth, and then it gives you the right to pursue the remaining balance against the consumer in a similar process to recovering a car, selling a car, and then pursuing a deficiency balance complaint in the courts.
That's exactly right. The only thing I would add is just keep in mind that we're talking about this in the context of a bankruptcy case. So all of the actions you would normally pursue in a typical replevin or repossession case, instead they're all being pursued in the bankruptcy court instead of the regular state court action you might be pursuing them in. So I wanted to just explain a little bit further regarding something we both mentioned on or touched on, that is the interest. And in bankruptcy court, all the attorneys I always work with, we all know the term till interest, and it's a very important thing to understand if you're a secured creditor as well. Till interest, it's actually a reference to a Supreme Court case from the early 2000s, but it is essentially a rule that has been decided by the Supreme Court that says when a debtor is repaying a secured loan through a Chapter 13 bankruptcy plan, they don't have to pay the contractual interest rate. It's unsurprising that a debtor might sign a car loan with a pretty high interest rate if they had some rough credit history, so they might be dealing with 10, 15, I've seen even 18 or 19% interest rates on auto loans. When we're talking about this in a bankruptcy, courts say you don't have to pay that contractual rate. That is just simply too high. Instead, they've developed what's called a prime plus rule. This is determined based on the national prime rate as it's reported in the daily press, and really the time the bankruptcy case is filed is that you need to be concerned with. It's that rate plus a risk adjustment as determined by the bankruptcy court. And I also just want to point out this isn't something specific to Cramdowns. This is actually something that applies to all types of secured loan repayment in a bankruptcy case.
So Cam, a question that I have is, what if the till interest is lower or higher than, I should say, what if the till interest is higher than what the rate on the loan was? If you have a 4.5% car loan, which you don't see those anymore, but if you did, sure. And the till interest is now 10%, does the till interest adjust upward to the 10%, or do you get the lower of the two?
Sure, so that's actually a great question, and this is one point where fairness really does come into play, and that's a good thing for secured creditors. So generally speaking, as you pointed out, till interest is something that benefits the debtor by allowing them to reduce the interest rate on the auto loan through this cram-down process. But as you just pointed out, it's always till interest that will apply. That is the answer here. So if you have a situation where you issued a loan with a very favorable interest rate to the debtor, and then in a situation that we've seen in recent years, interest rates go much higher than they were for a very long period of time, you, the creditor, now get the benefit of that higher till interest rate, so you can actually request that the creditor, or the debtor rather, pay higher till interest other than what the contractual interest rate provides for.
So it may in some ways not help the consumer or the debtor, however you want to put it, that the till interest gets applied. They don't get the benefit, but they also don't get, they get the benefit in some cases, but also the harm.
Exactly, that is correct. Now, moving on to back to the cram-down process specifically, and as I mentioned before, it's all about the debtor's eligibility, not so much the creditor's position on the loan. So there's a couple statutory sections of the Bankruptcy Code, which I'll point out, this is a federal law, so it applies in virtually every jurisdiction in the United States. Some local courts have kind of their nuanced rules that they follow, so always important, like everything else we talk about, to check with your local jurisdiction. But generally speaking, these federal laws will apply. And the first one is a determination of secured status. So this is actually a process the debtor and the bankruptcy court have to go to determine what the value of the vehicle is for purposes of the cram-down. And it's, again, limited to Chapter 13 cases, so there is another section of the Bankruptcy Code in that chapter that essentially just says a debtor only has to pay through their Chapter 13 plan whatever the secured portion of your claim is, you being the creditor. All right, so there is one major exception to this cram-down rule, and that is what we all call the 910-day rule. So that, in essence, means a debtor may not do this cram-down process if they purchased the loan or they incurred the loan 910 days before filing the bankruptcy or sooner. So if it's within that window, which 910 days just works out to 2.5 years, if that is how recently the loan was incurred, then the debtor is unable to pursue the cram-down process. Now, Scott, I've come across this before. Maybe you can answer, but can a debtor cram down a loan if it's issued to them on a vehicle they already own? So what I'm talking about here is if a consumer already has a vehicle, but they come to your institution, they want to borrow, say, $5,000 or $10,000, and they offer up their vehicle they already own outright as collateral. Is that loan something that can be crammed down?
Yes, it actually can be, even though it's within that 910 days, because the rule only applies to purchase money loans. If it's just a loan, a personal loan that is backed by a security of the car, then that doesn't fall within the exception. So they do have the right, ironically enough, to cram it down should they want to go that route.
Okay, so what you're saying there is It's almost riskier from a lender's perspective to issue these loans on already owned vehicles to consumers because they can pursue that cram down process without waiting the 2.5 years.
That's correct.
Okay. All right. So essentially what the effect of this cram down process is, assuming the debtor qualifies, the court determines the fair market value, and they pay a satisfactory interest rate. Any of that unpaid portion of the loan, we're going to consider that unsecured, and in bankruptcy court they call it bifurcating the loan. You're splitting it in two things. So you still have your secured loan, but it's based on the value as determined by the bankruptcy court. Now you have your unsecured portion. So when that process is complete, it's important to file an amended claim, separate out those two components of the loan, because there's still some opportunity to get paid on that unsecured portion of the loan. So in considering this process, there's just a few things overall in the bankruptcy that you need to review, both on the loan contract, the Chapter 13 plan. But Scott, can you give us a bit of an overview about what a creditor should be looking for if they think that their loan is subject to a cram down?
Yeah, so the first thing is the rule we just discussed, the 910-day rule. The question is, will that apply? The second thing is the question as to interest rate. Is it reasonable to cover the prime plus interest rate? The third category is the valuation reasonable or fair? Is the person using a Kelley Blue Book or something equivalent to that, or are they saying that they know a guy who says that this is what the car is worth? The next one is whether a debtor will pay an unsecured portion of the loan. That's another factor. And then the final one is, are non-filing co-signers eligible? So in something like this, and you see it frequently, can a lender pursue a co-signer outside of the plan of the Chapter 13 bankruptcy?
Sure. So just to touch base on that, generally speaking, when there's a co-signer on an auto loan, you still have to seek relief from the automatic stay, which is a topic we've covered elsewhere. But I strongly recommend you get yourself familiar with that. Check out our other webinars for a more detailed discussion. But assuming you've obtained relief from the automatic stay, you could then pursue recovery against the co-signer. But another thing I wanted to point out with that is, in my view, if there's a co-signer on a loan that a debtor is trying to cram down, but that co-signer is not in a bankruptcy case, what you really need to do is communicate with the debtor's attorney to avoid a situation that arises when that Chapter 13 case is done. So you know they're eligible for a cram down, they've done all the right things to obtain a court approval of that cram down process, and then they've completed their Chapter 13 plan and you still have this unsecured balance. Well, because of that non-filing co-signer, you can still enforce your loan as a secured loan against the person who didn't file a bankruptcy. So that means proceed with a repossession as you normally would, replevin action if necessary, and then pursue a deficiency balance. Now, this is all course of action taken against the non-bankruptcy filer or non-bankrupt debtor on the loan, but more often than not, the debtor doesn't want to have that happen to the co-signer or themselves, in essence, is what's happening because you're enforcing that lien. So this is something I always recommend. Try to sort out right in the beginning of the case rather than wait till the end, so you don't have to wind up dealing with a contested replevin or repossession later on. So Scott, now that we're in the middle of this process, is it possible for a creditor to contest the interest rates that are being suggested by the debtor?
They can. The real world rule and what I understand is that people come to the agreement over interest rates. The counsel for the debtor and the lender, they come to an agreement on interest rates. It's not something that in the end gets very often contested, but you can ask the court to determine the risk level that should be applied, which determines how much extra should be added to the prime interest rate to make a determination on what the interest rate going forward should be. That is based on their bankruptcy schedules, their income. There's lots of factors that play in, but in the end, you're talking about a 0.5 rate change one way or the other. So whether or not it's something you want to factor in, or how much do you want to litigate over that aspect to get a slight, in the end, an incremental change, it's something you have to evaluate. It's not always recommended for that kind of a change. But the general rule of thumb is if you're in the range of prime plus 3%. That factors. Over the last few years, rates have gone up and down, so we've seen them as low as 4.5% to 5%, and as high as 10. Right now, we're closer to the 10 range. So it's always floating, subject to whatever the prime interest rate is.
Okay, thank you. So, yeah, like Scott said, contesting interest rates may not be the most worthwhile effort to pursue in contesting a cram down, but what I do see more often than not is a contest of the valuation of the vehicle. So, as I said, and as we've covered, the court determines what the secured portion of the claim is, and that's where there's the most room for contesting the valuation. But I will say it's always dependent on what the debtor is bringing to the table to suggest whatever value they want to propose. So you touched on it before, Scott, but we're talking about things like, is it a Kelley Blue Book or an NADA guide printout that the debtor is relying upon to say that this vehicle is worth what they say it is? Or is it something a little bit more authoritative? And what I mean by that is something that can actually be used as admissible evidence if this were to be decided in a contested hearing. Usually we're talking about an actual in-person inspection and appraisal drafted related to the subject vehicle. So if the debtor retains a professional to come out, do an inspection of the vehicle, write up a report about all the little nicks, scratches, minor damage, mileage, things of that nature that can drive that value down, you, the creditor, it can be pretty difficult to gain or to compete with that contested. You as the creditor, it can be very difficult to contest that valuation because of how detailed it is and the fact that there was a professional who drew it up, an independent party who made the valuation.
Now, as the creditor, do you have the option to hire your own expert?
So yes, you do. You can always get your own company or expert professional to come do an inspection of the vehicle. The debtor does have to provide access to the vehicle in the event that that course of action is pursued. And it may be worthwhile because sometimes there are companies out there who, they might write a really lowball appraisal of a vehicle just because it helps out the debtor. So depending on, what you, the creditor, are comfortable with accepting in this process, it can certainly be worthwhile to gain your own independent appraisal of the vehicle. All right, so now I touched on it a little bit before, but once we're past the valuation process, we've come to an agreement on the interest rate, and the debtor's Chapter 13 plan is submitted to the court, providing for this cram down of their motor vehicle loan. You still have that unsecured portion of the bifurcated loan out there to deal with. Now, this is important because, especially in Chapter 13 cases, there's still chance that the creditor is going to be paying, the debtor rather, is going to be paying some portion of that unsecured loan back. It could be just what's called a pro rata share. Maybe they're paying $5,000 to unsecured creditors. You're owed a chunk of that $5,000. In some cases, though, they're paying 100% to unsecured creditors, so your entire unsecured portion still gets paid back, just at no interest. That's the one thing you're losing out on there. So it's important to amend your proof of claim and ensure that your unsecured portion is just as protected as you otherwise would for any other unsecured claim that you might file. So, Scott, I'd like to jump ahead a little bit. In recent years, the pandemic has wreaked havoc on many things, one of which being the used auto market. So, what are we seeing now, and why are cram downs so important to understand from a lender's perspective?
So the cram downs are important because, as you indicated, during COVID, used car prices and prices of vehicles in general went all over the place. Used cars, you would see things where they were being sold for 200% of their fair market value if you were to look in a Kelley Blue Book. The issue is now a lot of those, or not a lot, but a number of those loans are now going through the bankruptcy process, and they're not being valued, the vehicles are not being valued at what the fair market value was at the time of the purchase. They're being viewed in the fair market value of today's market. So you can see huge discrepancies between what they might have purchased their 2018 Honda Civic for during the pandemic in 2020 or 2021 and what that same car is now worth today. There can be, $3,000, $4,000, $5,000 in a difference in appraisal values. So it's it's lowering or increasing the unsecured portion of these loans that the lenders are now having to deal with.
Sure, and that is certainly a big problem that we're going to be seeing as we're now more than 2.5 years beyond the data or beyond the pandemic, bulk of the time, and we're seeing these values come back to normal, what we expect them to be.
It's great for the consumer, but not great for the lenders holding the remaining contract.
Sure. So just to kind of touch on a few other things to wrap up here. As I've mentioned throughout this episode, this is something that only applies in Chapter 13 bankruptcy cases, so that's important to keep in mind. But I do just want to briefly mention there is a similar process that allows a debtor to do effectively the same thing, called redeem the vehicle in a Chapter 7 bankruptcy. Instead of a payment plan, though, however, that is a lump sum payment they have to make within a relatively short period of time to gain the benefits of this reduced principal balance on the loan. And similarly, there's another process in Chapter 13 cases that applies to real property. In that one, we call it strip down instead of a cram down. Don't ask me why I didn't come up with these terms. But a strip down is a whole other topic on itself. I recommend you just reach out to me or Scott for details on that if you run into that situation. But similar to what we just covered, it's all about reducing balances owed to the fair market value of the property. But in that case, much more complicated, so we'll have to cover that another day. All right, well, thank you again, everybody, for joining us today for this episode. As always, please fill out the survey that you're going to receive a link for at the end of this. We do really appreciate all the feedback we receive and use that information to determine what topics to be covering in future episodes. Please stay tuned. We have another episode coming up in a couple of months regarding communications pursuant to the TCPA, which will have a ton of informative information. As always, feel free to check out our past webinars that can be found on our website. Now we're producing a variety of topics and series. Obviously, our Ask a Pro series is always doing well and covering a ton of good information for you. Coffee with Casey is always covering great, useful topics. And a new addition to our webinar series, Commercial Collections Corner, has a couple episodes now. So check all of those out for more details on any topic you may need. You can find mine and Scott's contact information here on the screen. So any topics we didn't cover, feel free to reach out with any questions you might have, and we'll get back to you generally within 24 hours, if not sooner, on those. Lastly, Scott, I think it's time for us to grab a couple of blonde ales. We will be trimming, grilling, and chilling as we take your questions.